Hey folks, welcome to Abrenio Law's podcast. I'm James Abrenio, your source for Virginia law and interesting issues. And today I've got a really couple very interesting guests, Michele Lewane, as well as Christian Kline. Am I pronouncing that right, Christian? Chris?
Yes.
Yeah. So the reason I wanted to talk to Michele and Christian is doing personal injury work. A lot of times workers' compensation issues come up, and Michele is my go-to person. And so I wanted to bring her on. I figured I have a lot of clients that will ask me questions, and it's oftentimes call Michele. And so I figured let's just put her up and give her an opportunity to kind of speak to you directly. And so I just wanted to give a little bit of background about Michele. She started a law firm, and the main office is down in Richmond, Injured Workers Law Firm, where she represents solely injured workers on workers' compensation claims. And Michele, I know you got your main office in Richmond, and I think you're still, are you still with Ben's office up here in Fairfax?
Yeah.
And just a little bit of background, my former partner, Ben Glass, that's actually who I met Michele through, very good attorney here in Fairfax as well. And so they work together. And so if you got a case up here in Fairfax, she could make herself or one of her team members available. She practices all over the state, so whether or not you're in Northern Virginia, Richmond, I imagine you even go to the Southwest and everything in between, I imagine, Michele, right?
Correct.
Yeah, and so UVA undergrad like myself, as well as Christian, graduate of University of Richmond. If I read that correctly, you were top of your class as well. So you're just showing off. And 30 years experience. And I, again, she's well respected in my community, the personal injury, as well as the criminal defense community. She teaches continuing legal education courses. She's a mom, and she makes herself available for younger attorneys like me. Just a little bit about Christian. It sounds like, Chris, you just joined the firm about 10 months ago. You're in and out of hearings every day. Grew up in Yorktown, also a UVA graduate, and just finished up at Regent University down in Virginia Beach. So first of all, thank you guys for showing up and being willing to talk with us today.
You're welcome.
So I figured what I would start off, Michele or Chris, and I guess you just take it as it comes. Just a kind of a 1,000-foot question. So if somebody's injured in a case, when should they be looking to a workers' comp attorney? What does that even mean? What does workers' comp attorney mean?
It basically means if you're hurt at work, there are some circumstances that would be covered by workers' compensation. So not every work injury is covered by workers' comp. So, for example, if you don't know why you fell, or if you're in a car wreck and you're not wearing your safety, your seatbelt, that's considered a violation of a safety rule, so that wouldn't be covered. Or repetitive injuries are not covered. So if you're consistently doing something and your back is hurt, or you end up at the end of a day of lifting something all day long and you tear the rotator cuff in your shoulder, that's not going to be covered if you can't pinpoint exactly when it happened.
So it's got to be like an acute injury, a one instance type deal.
Has to arise out of the course of your employment as well. So you have to be doing something that's related to your employment. You can't just be, say, walking from one place to another at work and you fall down for everything. That probably won't.
And something you did say that was interesting. You said if you don't know why you fell. So I guess that also falls within the scope and cause. It's got to be, you got to show that it's actually related to employment. Does that sound right? Okay. Now, can just briefly explain the difference between workers' comp and a personal injury attorney in the way you would explain it. And if that's a bad question,
a personal injury lawyer, in my opinion, covers almost everything. It could be medical malpractice, it could be auto insurance, it could be a slip and fall in a grocery store. And a workers' comp attorney is handling injuries that happen at work, and then with the conditions that we just talked about. Now, a lot of times they intersect because, again, a car accident is the most obvious one, where you're at work and let's say you're a salesman and you're driving somewhere for work, and you are rear-ended and somebody else is at fault for the injury. Then you would have both a workers' comp claim and a personal injury claim. Now, if you are at fault or like negligent, like you accidentally overcorrected and ran yourself in a ditch, it would just be covered under workers' comp and not personal injury.
So you can be at fault for your own work injury and still be covered under workers' comp?
Yes, as long as it's not a violation of a safety rule. You're not drunk. The reason, you're not going 90 miles an hour in a 25-mile zone. You're not violating a safety rule. So if you are, I guess in your world, people are negligent. They accidentally didn't see a stop sign, or they accidentally didn't turn their blinker on. I don't know. There are certain things that you would say are negligent, so technically you would be at fault, but it was more of a true accident versus some type of willful misconduct. Then yes.
Yeah, and so that's sorry. Go ahead, Chris.
I was just going to say, a good thing about workers' comp, even with the willful misconduct, is that is a defense that the defense has to prove, rather than something the employee has to prove it didn't do. So the burden of proof shifts in that situation.
So that's fascinating because, and just to kind of a comparison, under a personal injury claim, if you're 1% at fault for your own accident, you're barred from recovery. So that's pretty cool, and that's a much, and I hadn't realized that's a much wider availability of scope of coverage. So that's great. Now I oftentimes have people call me and say, James, I want to sue my employer. Talk about whether or not you can sue your employer, and how does the workers' comp framework differ from just, hey, I'm going to sue my boss?
It's funny. I get people who say, I want to sue my employer, and then I have people who say, I don't want to sue my employer. And neither is what you're doing in a workers' comp claim. You're basically filing a claim on their insurance. So it's really a claim with insurance. Your employer has been paying this monthly or yearly premium, and this is the benefits you get because of the workers' comp insurance. So you can't sue your employer. There is no pain and suffering. There is no, again, a coworker's at fault for the act. Workers' comp is a no-fault system. So what that means is it doesn't matter if it's your fault, like we were talking about a moment ago, but it also doesn't matter if it's a coworker's fault or if the employer didn't use safety equipment. There's no, you'll never be the same again. They only have to pay you, the benefits under the act, not nothing for pain or suffering. So you can't sue your employer. Your employer is totally protected with having the insurance, so you can't sue your employer.
I would say, correct me if I'm wrong, but workers' comp is easy, but the benefits are more limited in general.
Sorry, you cut out a little bit. The benefits are what in general?
Are more limited.
Okay, and that sounds right to me. That being said, and Michele, you actually did pop something in my head. Once in a while, I do have employees that will say to me, and I'll talk to them about the personal injury claim aspect of it, and say, hey, you need to contact Michele, and they'll say something to the effect of, well, my employer doesn't want me to file a workers' comp claim. They're worried about getting in trouble. What kind of advice would you give for an injured employee to help maybe quell those fears, or how do you address that situation? What advice do you give when you have a reluctant employee?
Unfortunately, in my opinion, there is a lot of retaliation, but they really need to look, and it's illegal.
Yeah.
but it gets done anyway. They'll fire you not because you filed your workers' comp claim. They'll fire you because you were 30 seconds late or you had a bad attitude. Because in Virginia, you're an employee at will. But I can also tell you, it's not because you filed the claim. It's probably they're going to retaliate because you actually are injured.
Mhm.
And I unfortunately, that does happen. Now, with that being said, it is the insurance they're going after. They're not suing their employer. It is a claim. The insurance, if you have a legitimate good employer, then they have good workers' comp insurance, and you're just filing a claim. It's like using health insurance, or if you get in an auto accident, having auto insurance. Now, if you don't, then there's statute of limitations, and you've got 30 days to notify your employer that you got hurt on the job and it is related. And I can tell you, if they're telling you not to file a claim, they're going to deny that you've told them this. So you have very little room to get treatment and benefits. And again, if you have, and I don't mean to discount a sprained ankle, but if you have a sprained ankle, it's going to recover. So what if you pay for all that out of pocket? But if you have a back injury that you think is mild, and doctors are always saying they're a lumbar strain, and then the next thing you know, you have an MRI and you have a herniated disc and you need surgery and you're never going to be able to do your job again, and you never filed a claim, your whole life and medical health is at stake, and it's just not worth it. It is just not worth it. So if your employer is telling you don't file a claim, I can tell you that's not the type of employer you would want to have.
That's an interesting answer. Now, you said you need to make the claim within 30 days. Like, what steps do you advise to make sure that that's not a disputed thing that you actually did? Do you recommend writing? Do you recommend email forms?
Yes, and it can't be that I have a hurt back. It has to be on such and such a date while I was doing this activity at work, I hurt my back. Okay, that's the type of notice, and it's a 30-day notice that you have to tell your employer. Ideally, it's in writing, and that you've gone to the doctor and you've said the same thing in the medical, so that the medical records say the same thing. That's the best way to protect yourself.
I see this issue in the personal injury world. If you have a claim against the county on, let's say, a car accident or whatever the case may be, you're required to give a notice of claim within, I think 6 months. And so what I end up doing is I give as much detail, photographs, all that stuff. There's usually a reluctance to give too much information, but for claims against the county, I overshare. Do you kind of give that same advice here, or is there kind of?
Yes, yes. Another thing is, again, if you have coworkers who witnessed it, that you make sure they're or verifying that it did actually happen. So that way, again, your employer says, you never told me. Well, there's witnesses. Well, it's in writing. Obviously, if you file what's called a claim for benefits within 30 days, it's no doubt, and that's, a lot of times when people call us, we're telling people to file their claim for benefits right away. And that usually is good,
And just to break it down, when you say claims for benefit, can you kind of explain what that is versus just writing an email to your boss?
The first thing we're talking about is notice, and that's a very quick requirement. You have to do that within 30 days. And just as an example, based off of what Michele was saying, I have a couple cases where I'm probably going to lose, where we are probably going to lose because the claimant has noticed to their supervisor, but it just says, hey, I hurt my back lifting. It doesn't say I hurt my back lifting this at work. They're not going to have notice that they were hurt at work. They just have notice that they were hurt at work. But the claim for benefits, Michele was saying, that can cover you on notice, but that's actually you basically initiating suit. You're filing for your medical benefits and lost wages if you have any of those. and you're notifying the commission about it, and that takes care of the statute of limitation, which is 2 years from the date of injury.
Okay. Okay. Yeah. So that makes a lot of sense. So that would be an analogous situation where I would literally just file a lawsuit in the county
Right.
and then give them notice. Okay. So that totally makes sense.
That also starts the litigation process. Once that happens, the insurance company employer has to respond within 30 days.
Yeah.
Now we
Whether
talked.
they're accepting it or not.
Now we talked a little bit. We talked about the employee. Let's say you're an employer and you have a workers' comp. So, for instance, Michelle, I actually think I called you about this as I was hiring my first employee. Should I get workers' comp insurance? If you had the voice, the ear of an employer, and they're worried about like workers' comp claims being made, how do you quell their fears? How do you encourage them to not break the law and to not be afraid and to really be involved in the system as well?
Well, I guess my first advice is to make sure they have a reputable insurance company that they are paying their workers' comp insurance to. Okay, because if they are, then that is the cost of doing business. You pay for insurance just like people pay for health insurance, to cover it. And what's good about it is it's on another level, it's a benefit to themselves as well as their employees, that the employee, if they're hurt, it doesn't matter whose fault it is. So like, let's say there's oil in the warehouse or a defective forklift. I mean, he's not going to be held responsible and sued for millions of dollars, for that defective equipment. It's just going to be his insurance covering the medical bill and his insurance covering the the time out of work. So, and if it's a small business, they can elect to have themselves also covered. So, it would be if they themselves, got hurt at work.
Yeah, and I will say I did take your advice. Even though I've only got an employee, it just made me sleep better at night to know I'm covered. A lot of these insurance issues, I think a lot of people sleep better if they're not paying the $20 a month or whatever. I'd rather invest that way. I sleep well at night if something bad happens.
Right. Exactly. That's
yeah.
They're not going to go out of business over workers' comp. I mean, over a work injury. That's what they're being protected for.
Like most people think of, I only need workers' comp if I'm a construction company for warehouse, but we know of a law firm where there was a legitimate workers' comp claim where someone was hurt using the copy of the payment. I think that firm was probably glad they have the insurance, so it can happen anywhere.
So, rule of thumb: get more insurance. It never hurts. So, now. Issues with doctors. Let's say I'm injured on the job. I notify my employer and I just run to my doctor. The doctor I always go to, whether it's an orthopedist or a chiropractor or whatever. What's your advice as far as, can they just go to their doctor or do they need pre-approval? How does that work?
You want to answer that?
Well, I can answer it in a way, but Michelle probably will want to jump in. Usually there is a standard, if it's not a life-threatening injury, you're going to go to the hospital, obviously, go from there based off if there are referrals and things like that. But if you hurt your back or something, then usually your company will know where to send you, whether it's patient first, urgent care, something like that, and then they'll give you a referral from, say, an orthopedic doctor. And from there, if they're accepting the claim, the workers' comp insurance company has to give you a panel of 3 doctors to choose from. They can't just force you to go to a certain doctor, but you can't just choose whatever doctor you want. And you choose from that panel and go to that doctor. Normally that becomes the treating physician who kind of runs the show from a medical perspective, and whose opinion is the most important in the case.
You can't change. Once you've picked, you can't change. And so it's kind of a two-edged sword. Sometimes you love your doctor, and that's wonderful because the insurance company hates the doctor, but you're safe. And sometimes you hate the doctor, and you're pretty much stuck.
Yeah, and that is a question that I was going to follow up with. If you're in that situation where you hate your doctor, what is the advice there? Is it just stick with them? It is what it is, or is there any? Do they have options?
Well, settlement is usually what I'm trying to do at that time, is try to settle the case so you can go manage your own medical care. But there's 2 or 3 ways you can try to get rid of your treating physician. One way is you ask them to refer you to somebody else. Sometimes they will. Another is to ask the other side, will you be willing to change treating physicians? That happens on a rare occasion. They might agree that this is a bad doctor and they're not. Again, they might agree. And then the third way is you go to the commission and with a hearing and you ask for permission. But unless that doctor is committing like medical malpractice and you can prove it, it's not going to happen there.
So it sounds like probably.
Like if you don't like his opinion, you don't like his treatment plan, that's not going to matter. Okay. But if he's saying, I can't think of anything, but literally medical malpractice, how high a hurdle that is.
Yeah.
So,
a follow-up question to that, because in the PI world, causation is a huge issue. And you were talking about the soft tissue injury that turns out to be a herniated disc that turns into surgery. What they're going to do in the personal injury world, the Geico or whatever is going to claim that's pre-existing condition or it has nothing to do with the accident. How does that work in your world when you're litigating those issues, and particularly if you got a doctor that just is not great? How do you navigate that issue?
It's very similar in our world, where the defense, of course, is going to want to assert that thing, or nothing to do with injury, like you said. And back to the treating physician, their opinion on that is very important. The ideal situation is that it's in all the notes, the doctor's notes from the start, that this injury is related to, it's related to the work accident as caused by it. A lot of times we don't have that from the start, and we have to send a medical questionnaire, talk to the doctor, which is very expensive, or do something proactive to try and get causation. The good news on that front for workers' comp, and I don't know how it is in PI, but even the slightest aggravation of a pre-existing condition, as long as it's related to the treatment and everything, it's covered by workers' comp.
That's interesting. These decisions, these factual findings, I assume, are made by a judge, not a jury, right?
Correct.
What do you think, and this is probably a bad question, but it's one I think that I have, is slight aggravation and the likelihood that the judge is going to find slight aggravation in those questionable cases. Is that going to be a hard issue, or do you think you're usually going to win that, or is there a way to kind of give me an idea?
Well, it's a kind of a twofold. So the treating physician's opinion is given great weight. And so they will have independent medical evaluations by doctors that will say it's not related. And so your doctor says it is related. Okay, so technically, all other things being equal, the treating physician should win. But it depends on the hearing, the commissioner hearing the case and different things like that. Then the second little subpart question is, aggravations of pre-existing conditions are covered. Under workers' comp law, it is a reason, however small, however slight, however one iota is even the terms in the legal treaties or whatever you want to say, but case law, that's what I want to say. Why? So if you have a bad knee or have a bad back, and you fall in a hole at work and it jolts your back, and now it's herniated, and now so at trial, what we as your lawyers are trying to do is going, did you have burning pain in your back before? No. Did you have the tingling down your leg? No. Could you sit up, stand, not limp, whatever, so we're all going about all the symptoms that they were working full duty fine, even if they did have the herniated disc, you just don't know. It might get sore every now and then, but boom, the accident happened, and now here are the new symptoms, or here are the things that had never happened before. And that's kind of, so it's a little bit of the client's testimony, a little bit about the case law, and then again, who's giving the causation? You know, is it the treating physician? Have they gotten another doctor out there to say something? They have video of, I mean, you know, they have private investigators. They have video of the client, you know, splitting logs in the backyard, you know, and then, you know, then there you go.
More of on a technical side, as far as causation and evidence, are you bringing doctors in live to testify, or is this on the papers? How does that work?
All paper. Luckily, there's, with medical evidence, doctors charge for us to talk to them, and doctors will charge for reports. But that, even though it's technically hearsay, all that is brought into evidence. All the medical records are brought into evidence.
Wow. That's got to be interesting from a presentation standpoint. And maybe I'm getting a little too technical here for people watching, but how are you just handing the judge the papers and saying what they say? How do you present that evidence at trial, or do you just, they take it back and review it? How does that work?
You have what's called a medical designation. So you have a legal obligation as soon as you receive medical records to electronically file them with the commission and give them to the other side. Then, so technically, the judge has all medical records, probably duplicative medical records. And then at the hearing, you're giving something called a medical designation. So it's kind of like with a table of contents. And so it will be, I will give a medical designation of all the medical records I think support my case, and the other side is doing a medical designation of all the medical records that support their case. And so then we're turning that in as an exhibit.
Okay. And I assume then you're arguing at the close of the case. And
I wish. There's no opening or closing statement.
Wow. Okay. All right.
Hearings are 30 minutes long, and I can tell you it's crazy trying to even cram what we do try to cram into those 30 minutes.
That's amazing. I mean, when we have like speeding trials, it's more than 30 minutes. So, wow. Hats off to you to be that efficient. So, wow. Now, let's talk about my world, the workers' comp lien that terrifies me as a personal injury attorney. Kind of explain to me from your end what you want the client to be doing. Also, like red flags about if your personal injury attorney is going to screw something up. How do you prevent me from messing up my cases, and how do you give your clients the availability to, or the ability to say your PI attorney sucks?
Well, I always, the nightmare that happened quite a few years ago, and there was a major bar complaint against the PI attorney, and it was founded, and unfortunately the client came to me after the fact, but basically the facts of that situation were that there was a policy limit. I think it was only $25,000. So the attorney, they tentatively agreed to accept the $25,000 policy limits. I mean, and if the case probably was worth maybe 50 or 100,000, but you know what I mean? It was like that limits, that's what you're going to take. It was very small. He puts it in his trust account and then decides to call the workers' comp carrier. That's considered fraud, all kinds of things. And my client lost all his workers' comp benefits. And the attorney got a bar complaint, and that was founded because you cannot do that. You cannot, even though it's in the trust account, even though, you cannot do that. You have to notify, you have to notify, the PI lawyer must notify the workers' comp carrier and must get their consent before anything is actually funds are transferred in any way. And so, and then at that point, so that's my horror story that I tell people, because I couldn't even, it was all an innocent mistake. I mean, we're not talking about the damage to my workers' comp client was bad, because he was getting a weekly check, lifetime medicals, and he would, I mean, for $25,000 was nothing. You know what I'm saying? For what he had a serious injury, and he lost everything, all his benefits because of it. And he didn't, obviously, he was trusting the personal injury lawyer to know that you don't do that. You have to notify the workers' comp carrier. So now, with that being said, there's also ways to negotiate the personal injury lien. I mean, the workers' comp lien on the personal injury case. And there's, ways you can do that. But now I've forgotten your question, because I just was trying to remember that horrible situation.
Yeah, well, and my question is how do you, if you're the employee, the patient, what are the signals that your PI attorney is screwing up? And I imagine the first is they're not talking to you about your workers' comp claim and how
they're not talking to the workers' comp, their workers' comp attorney, or if you don't have an attorney, they're not talking to the workers' comp insurance carrier. Because they have the obligation, affirmative action. They have to reach out. It's not like, they should have known there was a lien, or they should have already, they would have, of course they would have consented to this. None of that. Mm-hmm. They have to overtly do it and get it in writing. And so then the key is, that's how you would know, is that if they're saying, I've had people say, well, I don't handle workers' comp. I know nothing about workers' comp. Well, that's fine, but you better know how to handle the workers' comp lien.
Mm-hmm. Well, and I can tell you, and you know this from experience of me sending you constant emails, whenever I have, as a personal injury attorney, if I have somebody injured on the job, the first thing I'm doing is hire a workers' comp attorney.
Right.
That makes it the easiest for me, because then the workers' comp, you are directing me, hey, you can do this, this, and this. One of the questions that I oftentimes get is, did you hire a workers' comp attorney? I reached out and I decided not to hire them. Talk to us PI attorneys. Tell us when we should question that about them not hiring the workers' comp attorney. When should we push them to hire a workers' comp attorney? When do you think it makes sense for an employee to hire a workers' comp attorney? Does that question make sense? It's probably loaded, but I think it's all the same question.
Yeah. Couple of things. One would be if anything is being denied. So if medical treatment is being denied, okay. Another, or they're having a hard time getting their weekly check. Another time is when it's time to settle the PI case, because the ideal time to settle the workers' comp case is really right before you settle your PI case, or at the same time. It is a nightmare to settle your PI case and then try to settle your workers' comp case. And if you don't settle your workers' comp case, it's very complicated, the mathematical crazy formula that you're put under, that it would not be worth it for you to pursue. Basically, the workers' comp carrier gets to eat up all your personal injury fund before they have to pay any more of your benefits anyway. So you don't want to go there. So you'd rather settle your workers' comp case first. Or at the same time as your personal injury. The other time is really if you think you are not going to be able to go back to work, or you need surgery or any serious thing, because you want to make sure all the legal documents are up to par, that you're under an open award and all those things. Again, if you have a small injury and you think you're going to be back at work in 3 months, maybe you don't need a lawyer. But then your workers' comp lien is going to be, $1,000, $2,000. It's not going to affect as much.
What about the small claims where the employee says, I don't want to make a workers' comp claim. I don't want to get in trouble with my boss. I'm afraid he's going to be pissed. I get that once in a while. What's your thoughts on that?
I mean, it's okay, but that it goes back to that 30-day notice.
Mhm.
You want to risk that you think you're okay right now because everyone's saying it's just a lumbar strain, when in reality you've got a herniated disc and you're going to need surgery and you're going to be out of work for a year. I mean, so it's this risk that they take because they have to give notice within 30 days.
Mhm.
So,
And
no.
just as a rule, whenever I always say, talk to Michele, I know
Right.
that sound right.
I mean, I see the worst case scenario. So, that's my problem. You're talking to the wrong person. Like a lot of times people might, I can't even think of anything, just, fall at work and bang their knee up, and it's just a bruise. I mean, you're not going to miss any time from work. You don't really need to see the doctor. Sure, don't report it. But if you're needing medical care, that's where it starts getting kind of more tricky. You're going to really pay your own personal, and you're going to use your own personal insurance, and you're going to use your own vacation time. And then come to find out, it's not. It's more serious, and then that's going to be on you, and that happens often.
Yeah, and I always say to them, my view, and this is even with personal injury, car accident cases. A lot of times there are small cases where I recommend them settle themselves because I'm maybe add you $1,000 by the time you pay me. But I always say it doesn't hurt to talk to an attorney. I think you do free consultations. I do free consultations. Just talk to an attorney. So, and if you want to make that decision after you've been educated, that's yours to make. But I'm like you. I'm like, why waive that? Now, one of the questions that scares me when I'm kind of coordinating with the workers' comp attorney or the workers' comp insurance company, I hear the term lifetime benefits, and then I hear you say it's a mess to try to deal with that after the PI case. Can you kind of break that down a little bit more so it's less intimidating for me as the attorney? When I hear lifetime benefits, I'm thinking huge numbers. I'm thinking, you're going on vacation and all that kind of stuff. Simplify that for me. Explain why it would make sense to go ahead and get it settled now rather than give up this lifetime benefits type thing.
Because and it's ironic when you hear deputy commissioners even trying to explain it that people see that term lifetime medical benefits and they go, oh wow, that's awesome. It's as long as you go, it's lifetime medical benefits as long as you go to their doctor that they pick, no one else, as long as that doctor says your current situation is directly related to the original accident. So if you have a year gap in treatment, that means a year of no paperwork, which means that they're going to say nothing's wrong with you. So why are you going back to the doctor? Or they're going to say it's unrelated. Or you are in another car wreck. Or you are, something, you fall down the stairs at home. They're going to say, aha, it's no longer related.
Or they get 5.
Yes. Yes.
Well,
That say it's not related, right?
So let me ask you this. Let's say somebody goes, they're getting back treatment, physical therapy. They finish their course, 2 months goes by, and then they get into a small fall or something. And they say, look, that didn't really hurt me, but then I got treatment, but now I want to go back to my physical therapist. Are you saying there's a big chance you're out of luck there? Okay.
Yeah.
So the lifetime benefits isn't as dreamy as it seems.
Right.
Okay.
That to make sense to settle is ideally you have your own personal health insurance and future care that you do need. You can put on that. It's not necessarily you're paying for every doctor's appointment out of your settlement funds, but like I said, ideally you have your own personal insurance, and so you kind of take care of your future needs with that, and you get this lump sum of money with future medical value in there.
And now you touched on this earlier, but can you just break down the damages that you can claim in a workers' comp again?
So basically it's lost wages, and there are a couple different types. One is temporary total for the time your doctor is keeping you completely out of work. Another is temporary partial, where your remaining work capacity doesn't allow you to earn as much, and you basically get the difference in the wages you were making pre-injury and now what you can make after your injury. There's also permanent partial disability, which is basically once you are at maximum medical improvement, your doctor can assign you a rating of percent use of that body part you lost, and in Virginia it's only for extremities, your arms and legs. And based off that percentage, you're entitled to a certain amount of weeks of your average weekly wage, and that's the third type of benefit. There's also temporary total disability. I don't know if you argue better explain that. Not total, permanent total.
If you're paraplegic or you lose both your eyes or both your ears, I mean, you're totally blind or totally deaf, or lose two body parts, like two hands or two arms or two legs, you can get it or a brain injury, you can get it for life. Also, if you die, your beneficiaries can get these benefits up to 500 weeks.
Okay.
And then the last benefit is the medical that we were talking about, the lifetime medical benefits.
Now I'm gonna.
Actually, I take it back. Then there's $45,000 for durable medical equipment. So, like if you needed a car or you needed a ramp at your home or something like that.
That's interesting. I'm going to ask you a question that's kind of more cutting edge, more relevant. Obviously, we're all living through this COVID pandemic. You get a lot of questions about what can your employer make you do, and vaccination, all those kinds of things. And I hear the question often: if I go to work and I get COVID and I'm injured because of that, is that a workers' comp claim? How does that work? Tell me about that. What's your thoughts on that?
100% not going to be covered, except for one exception. It's not going to be covered because it is a ordinary disease of life. It's like if you caught the flu. How do you know you caught the flu at work versus from, your spouse? So it's not covered. However, the General Assembly created a law effective July 1, but it has a few defects in it. So it's going to be appealed, so we don't know what's going to really happen with it. But it says medical providers, nurses, doctors, first responders are covered if they get COVID, okay? Or basically what it is the presumption is they got it at work. So the burden is on the employer to prove that they somehow got it from home or somewhere else. But that doesn't cover teachers, that doesn't cover, factory workers, doesn't cover what you call essential personnel. Everybody else, they don't.
That's interesting. And you said that you saw some defects in the law just passed. What are you seeing, or what is the word about the?
Well, they made it retroactive. So they made the law. So they entered the law July 1, and they made it retroactive to, I'm not sure if it was March or April of when the pandemic started in 2020. So, that's like, the way I see it is, smoking, or not smoking, I don't even know what you do with heroin. Smoke it, what do you do with heroin? You shoot it, okay? So you're shooting heroin. And they say it's legal. Well, let me back up. They say it's legal to, let me do something better. It's legal to smoke cigarettes, right? So it's legal to smoke cigarettes. But then they created a law that said in July of 2021 that says it's illegal and a crime and you go to jail if you smoke a cigarette since anywhere between April or March of 2020. So they're making the laws go backwards. So you can't, how can they do that?
And that makes sense to me, because I, as employer, wouldn't be aware of that exposure that I'm doing anything wrong.
Exactly. Insurance companies don't know the exposure. So obviously I'm for the law because it helps my clients. It helps, we have several nurses, doctors, you know what I mean? So I'm for the law, but I'm very concerned about
retroactive.
Yeah, that retroactive portion.
Now,
Those types of workers are winning and settling their COVID cases for good value. So it's, if you fall into the categories of medical providers, responders.
well, I imagine hospitals and doctors' offices don't want to try to deny claims. That's probably not a good marketing look.
But that's what I think that's what they're doing is, some of the hospitals around here they are, they're having their employees, right on the front line, and then they're going to deny that they got it at work. It's crazy making. So
heroes work here, but we're not going to pay for them.
yeah, so it's not good PR work. I think that might be what's going on there a little bit.
Yeah. Well, and I mean, that makes sense. But it sounds like, as far as July 1 and beyond, it sounds like a tied up bill, and
yeah.
Okay, that makes sense. I appreciate that. That was very interesting, and you see a lot of pontification on Twitter and all that, and nobody knows what they're talking about. So thank you for that education. So I know you guys have appointments coming up before.
Yes.
Let me just open the floor. Is there anything that I haven't asked you that you think that would be useful for somebody, either that's an employer, an employee, a personal injury attorney, anything that you'd want to raise flags about, or any thoughts, any closing suggestions?
Just going back to the small injuries and work that file a claim. With workers' comp, it's very easy for people to get their claim started on their own. Just giving notice. You can get on the Virginia Workers' Comp website and file a claim really easily, as long as you have basic understanding of how to use a computer, and if not, you can call the commission and get them to send you the forms you need. So no, you don't really need an attorney right away, and we often don't take cases until they're like mature or something, until they're close to being ready to settle or they need to go to a hearing. But the answer, I think it's worth it, especially if it's something like your back or you hit your head or something that could develop into a serious injury. It can't hurt you. It's not a lot of work to do. Probably not nearly as much as it would take to file a personal injury.
People can file it on their own. They don't need a lawyer right away. But like you said, what we do, and I've also written a book that I give to people for free, basically to manage and handle their cases on their own, unless they need a lawyer.
Yeah, and I appreciate it. And again, I just can't emphasize enough. It takes 30 minutes of your time to call and get educated, and most attorneys are willing to sacrifice that time. So look, Michele, Chris, I appreciate your time. What I'm going to do is I'm going to put up some graphics with your contact information and website and all that. But for anybody watching, these are my go-to peoples. If you were injured on the job, I want to make sure that you're being fully educated about your rights. I want to make sure you're aware of, where possible funds can come to help you get through this difficult time in your life. But guys, I want to, again, thank you. If you ever need anything, reach out. Appreciate your time, and I'll be bugging you in the future.
Thank you.